Such. For everybody in the audience, it's Gorsuch. And I give my staff credit for actually getting it right, but I had a crisis of confidence when I saw the other cheat sheets. I want to thank you for being here. And Judge, I want to tell you, I grew up in the Southeast, and I love skiing. It's just never occurred to me to do it when the water was frozen.
Well, we'll forgive you that.
But I love the fact that you're an outdoorsman, because it means you love our environment, you love being outdoors, and you want to leave a good, healthy environment for your children and everybody's children. Senator Franken said that he had a career in identifying absurdity. I feel like I joined one when I joined the U.S. Senate. And I'm going to talk a little bit about that today. Yesterday I was saying I wanted to have you talk more and me less. I'm not sure if I can live up to that promise, because I want to go through a number of things. I'm a numbers guy. I like the fact that you've repeated the numbers and your track record on the bench. Best I can tell, if I double the number of cases that people have made at issue with you, that is 0.003 of your cases. 0.3 of what is that, 1,000th of your cases are in question here. And I'm going to go back to those because they're fairly limited. But before I do, let me talk about another piece of absurdity. Absurdity would be talking about how President Trump set some sort of a litmus test and not recognizing that candidate Clinton told a town hall audience, I have a bunch of litmus tests. We have to preserve marriage equality, and we have to make sure Roe v. Wade stays in place. That sounds like a litmus test. I wouldn't have used that comment by a candidate if we were going with the President Clinton nomination. I don't understand why it's relevant here. It's not you. We're here to talk about you and your qualifications. Another absurdity that I think we'll see over the next couple of days is the absurdity of people saying that you're sidestepping the questions about cases that may come before you. I actually think you're following a code of conduct. You're following a code of conduct for United States judges, Canon 3A6. You're following the American Bar Association model code of judicial conduct, Rule 210, A and B. I appreciate you respecting and living what you say, and that's the rule of law and code of conduct of judges. Now I want to get into some specific cases, and I guess I'll start with freedom of speech. Judge Gorsuch, I'm going to read some of the notes because I want to make sure I get my points right. I want to apologize again because I may do a little bit of talking, but I do believe the First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. I think the first few words mean something very significant, and I think that you do too. Now, clearly, this amendment is not meant to limit the ability of the federal government to curtail free speech. It is meant. Do you agree that the founders intended this amendment to be a check on the federal government?
Senator, that's what it is.
Is it fair to say that the framers, when they were crafting this First Amendment, were concerned especially about political speech as opposed to, say, activity like exotic dancing or other speeches or activities that people argue are covered by the First Amendment?
The Supreme Court has held that political speech is the core of the First Amendment.
So it's fair to say the Supreme Court has routinely held that political speech, especially during a campaign for public office, is at the core of the First Amendment.
It has.
A lot's been said today about money in politics and a landmark case called Citizens United. Citizens United is a very popular punching bag for some of my colleagues across the aisle. You spent a lot of time talking about this with Senator Whitehouse earlier today. If you listen to them on the subject, you would think this decision resulted in the ability for a corporation to pump hundreds of millions of dollars directly into political candidates. The facts of the case get wrapped around buzzwords like dark money. However, I want to use some of my time today to walk through the facts of this case. First, at its very baseline, this case was a challenge brought to a federal statute. The federal government, through Congress, passed a statute aimed at limiting certain speech. And it was Congress's activities in regards to speech that the framers were concerned about. In fact, the statute prohibited entities such as corporations, including nonprofits, and labor unions from using their general treasury fund to fund any advertisement that used a candidate's name within 30 days of a primary or 60 days of a general election, including to promote a movie, as well as many express advocacy communications. This case had nothing to do with direct contributions and spending coordinated with specific campaigns and candidates. In other words, this case is not about corporations making direct campaign contributions at all. Citizens United was about an entity's ability to speak independently of any candidate or campaign. Judge Gorsuch, do you remember what behavior was in question, or in other words, what the Citizens United wanted to advertise?
Well, as you say, Senator, there was a movie involved.
It was a movie available on demand in home. The organization wanted to broadcast the film or to advertise the film before a 2008 Democratic primary. The federal government went into court and said a nonprofit couldn't produce or advertise a movie highly critical of a candidate. Judge Gorsuch, are you familiar with the oral arguments of the case?
I remember listening to them on tape at one point, but it's been a while since.
Well, during the initial oral argument for the case, the government was asked whether or not the same law could prevent a company from publishing a book that was the functional equivalent of expressed advocacy. Specifically, Chief Justice Roberts asked if it's a 500-page book and at the end it says, "So vote for X," the government could ban that? The response from the Deputy Solicitor General, who was defending the statute, stated, "We could prohibit the publication of the book." In the oral arguments, Justice Souter stated, "To point out how far your argument would go, what if a labor union paid an author to write a book advocating for the election of A and defeat B? And after the manuscript was prepared, they went to a commercial publisher, say Random House. And Random House says, yes, we'll publish that. We're talking about how far the constitutional ban would go. And we're talking about books. The Deputy Solicitor General said the labor union's conduct would be prohibited. He goes on to say, I think it would be constitutional to forbid the labor union to do that. I want everybody here to know, and everybody who's listening, to realize the consequences of this position. The government at one point defended the statute by saying it could prevent the publication of a book by a corporation like Random House if the book advocated for or against a candidate. That's not the end of the story. The Supreme Court was shocked that the federal government would take this position and ordered re-argument. Then the Solicitor General, Kagan, slightly retreated from the government's position. Then Solicitor General Kagan said that while the law could apply to a book, the government had not applied it in the past. But when asked again by Chief Justice Roberts about a pamphlet, she responded, I think a pamphlet would be different. A pamphlet is a pretty classic electioneering. Again, I want everybody listening to realize what we're talking about here when we talk about Citizens United. They argue that there was a constitutional authority to actually prevent the publishing of a pamphlet opposing a candidate if produced by a nonprofit organization. If we as a country have a long history of people being able to criticize the government, which includes specific offices in government. Sometimes this was done anonymously because disclosing the speaker's identity had serious implications. Whether it was the American Revolution, the Jim Crow South, or today. Therefore, we must be cautious in giving the federal government, including the executive branch, power to limit or penalize core political speech. Judge Gorsuch, you may not be able to see that. Do you recognize this book?
I can't see it. I'm
We got this from the Library of Congress. It's actually, it has a number of Paine's writings, including Common Sense and other political writings. In this pamphlet, he urged American colonies to declare independence and sever ties with the British monarchy. What some of my colleagues from the other side have attempted to do is tie you to a court case which you had nothing to do with. They painted a picture of this case as support for big money in politics, where big corporations win and the voter loses. In reality, the facts of this case were much different. The federal government argued it could stop a movie because it contained political speech. Then it argued it could ban a book because it contained such speech. Then it argued it could ban a pamphlet because it contained such speech. That's the Citizens United case. I find it curious my friends are so concerned about executive power and not concerned about the federal government arguing its authority to prevent production of movies, books, and pamphlets. It's foundational to our democracy. So as I stated previously, they're attempting to link you to Citizens United and continue a narrative that I think is absurd, that as a judge, you will support big money and corporations and never side with the little guy. The facts dispute that. The number of cases you've heard dispute that. Now, I want to close out here with a little bit of discussion about some of the discussion about maybe your political positions or your past being instructive to the decision by some as to whether or not they should support your confirmation. Let's talk a little bit about now Justice Kagan on Citizens United as the Solicitor General. Let's keep in mind, and actually the reason that this came to my attention today earlier when people were asking about the role that you played when you were working as an attorney on behalf of the government. So who was your client?
The United States.
So let me go back to when Justice Kagan was in a position. When she was nominated, she was a lawyer at the Department of Justice. In fact, she was the Solicitor General. As we've talked about, she argued with Citizens United. Now, she pressed the argument that the government had the authority to prevent the publication, not only of movies, but other forms of political speech, like common sense. She accounted for her arguments as Solicitor General this way, her quote, "I've tried very hard to take the cases and to make the decisions that are in the interest of my client, which is the U.S. government." My guess is that's what you were doing when you were in a different role representing the U.S. government. So I don't think there's much power to the arguments if for some reason you advocated for the government, unless we want to go back and revisit now a Supreme Court justice's history in the same. I think that what she did was fine. Whether or not I would have voted for her, we'll never know because I wasn't here. But I also want to bring up one other thing. Another member brought up an email sent to you in 2004 where you noted that you had volunteered on a political campaign. Well, once again, you may recall that Justice Kagan also had quite a political career before she became judge. After she was nominated to the Supreme Court after reviewing her emails from the Clinton White House, the AP published a report saying that as a White House aide, she had a flair of political tactics, a flair for political tactics, and often had to place political considerations before her political views. And the LA Times reported she worked in the research department defending Democrat candidates from political attacks and conducting research on the opposition. I don't think there's much more to say about it either, except to say this. In spite of her position to think that things like common sense could actually be, banned, in spite of her political activities that seem to have reached to a far greater level than your own, when she came before this Senate, a majority of Republicans, or I should say non-Republicans joined with Democrats and through unanimous consent did not force cloture. They moved on to the vote, and quite honestly, Republicans were in a position to halt her, and I'm sorry, that's on Sotomayor. On Kagan, same thing. I had the wrong sheet up. On Kagan and on Sotomayor, Republicans respected the president's authority to appoint a Supreme Court justice, and Republicans did the right thing by moving forward and allowing the confirmation. So I think that we have a moral high ground here that my colleagues on the other side of the aisle should take note of. Now I want to get to other stuff. Judge Gorsuch, I want you to go back briefly. I've got 15 minutes, and I'm going to go really quick. This will be a lightning round. The ethics class. This is another, I'm going to go back to absurdity. I appreciate that Senator Franken mentioned what he did because it's a perfect theme for my line of questions. I heard, and there's going to be a lot of it spun in the press, and I want to see if maybe a few people will actually listen to the answers to these questions. It had to do with the letters that came from the class that you teach on ethics. Can you tell me again exactly, in brief, you discussed a curriculum, that a question that's raised in there. Can you very briefly, in about 45 seconds, kind of summarize that?
I can try, Senator. I'm very heartened by the fact that scores and scores of my former students have written this committee in my
And I'm going to seek a unanimous consent to put some of those letters into the record.
And over the last 7 or 8 years, I've used the same textbook. You can take a look at the teaching manual, and you'll see exactly what we discuss.
So it wasn't an arbitrary comment. It wasn't something that was done in this one segment. It was something that was a part of a well-thought-out curriculum, and it started a discussion that I have letters that, without objection, I'd like to submit to the record that suggest the same. But it wasn't something, it wasn't arbitrary. It wasn't off the cuff. It was something that was a part of a curriculum that had existed for how long?
7 or 8 years,
Okay.
Senator.
Okay, so I think I'd like to seek unanimous consent that that I can actually put forth a series of documents that have to do with some former students, speaking specifically to the letter that you were informed of the day before yesterday, and other students that were in your class that saw the facts differently, and some other documents that I think will be good reference for the other members to review without objection. Okay, now I want to move into a couple of things that I really want to get to. The Trans Am trucking. First off, you've given me hope that I could actually understand legal opinions when I read them, when they're well written, and yours were. One of them was your dissent on Trans Am trucking. These are things, you know, people talk, you're not here to have heart. You're here to judge the law. You're here to judge the Constitution. And I appreciate that about you, because I suspect you've got a really big heart. But I thought it interesting, I highlighted several parts in your dissent. One was when they suggested that he should drag the truck and instead of keeping it there or leaving it there, your parenthetical comment, that was an illegal and maybe sarcastically offered option. So you didn't consider that a viable option. There are going to be people here that said that you were okay with that. That's wrong. It's absurd. And then the other one was he could sit and wait for the truck to arrive, and you parenthetically said a legal if unpleasant option. You went on to say in your dissent, it might be fair to ask whether Trans Am decision was a wise or kind one, but it's not our job to answer questions like that. Our only task is to decide whether the decision was an illegal one. And then you go on to say that there is simply no law anyone has pointed giving employees the right to operate vehicles in a way the employers forbid. I think that if you go back and people read these dissents, it's hard for me to imagine that you arrived at this through any other conclusion but for the fact that Congress had not explicitly provided you the authority that you thought you need or the reference point that you thought you needed to judge otherwise. And my guess is when you rode home that night, you wish that they probably had. Now, I also thought what was interesting in your dissent on the last page is you actually, kind of gave some suggestions to maybe how things should have been done differently or how we should have done our job better so that maybe you would have been in a position to come up with a different judgment. But that's our job. You told Senator Whitehouse, it's not my job to do your job. That was one of your best quotes of the hearings today. And you're absolutely right. It's our jobs to make value judgments. It's our jobs to get votes, and our jobs to answer to the American people every time we get elected or go to campaign every 2 years or 6 years. So I, for one, think that you came up with a well-reasoned, fact, legally based dissent on Trans Am trucking. Now I want to move to one that I just want to make sure I have time to get to, because it's one where, quite honestly, I would have completely loved for you to go the other way, but you did the right thing. And it's purely by coincidence, and it really is. I'm wearing an autism pin today. Because I'm a big advocate for autism and Autism Speaks. I don't have any personal family experience with it, but it's something to me that's very important. And so Obviously, in Thompson, RJ2 School District versus Luke P., you all came up with a decision that was contrary to what I'd like to do for parents and families and children who have children with autism who are in the public school system and not getting the results that they would hope to get. And in this case, again, I think you got the IDEA absolutely right. There was not anything in the law that could have possibly led anyone. Somebody made reference to it in the opening comments. That's why I looked into it yesterday. But there's no way that you could have reached that far to support what clearly had to be, in this case, it was appeal, that would have been sympathetic to Luke P. and his parents. You made the right decision. You know what I did in North Carolina? I changed the law. I did my job. You made it very clear that the IDEA didn't do it, so as Speaker of the House, we went in there and when we said that a parent, after spending a year in public school, didn't think that their child was getting what they needed, then we would actually allow them to go to a private school and have money follow them so they can do it. So by doing my job, we've got a few hundred kids now who are getting the education that they need in a private school setting. Thank you for forcing me to do my job. It preceded my time as Speaker of the House, but we knew we'd run into problems there, and we solved the problem. Thank you for making us do our jobs. And then finally, the case, I want to go back to this real quick to make sure I get my notes right. Oh, speaking or talking against, one thing I like about you is sometimes your decisions seem to make everybody mad, which is probably means it's a pretty good decision. So I think sometimes maybe you even exceed the 50% rule. Like the case in
My
Riddle,
daughters would agree with you.
like the case in Riddle versus Hickenlooper. I mean, that's a position where the Democrats and the Republicans were spitting mad at you. Mm-hmm. And there aren't many more. I mean, when you put every other minority party that was being treated unfairly as a result of actions that were taken, I don't know if it were Democrats or Republicans in control when they passed that, but that was a classic example where you obeyed the law. The other thing that was interesting, or you respected the law. The other thing that was interesting about that case is you actually provided some food for thought on how maybe they could solve that problem that would be constitutionally sound. And I've found that in other examples. I love the fact that you don't believe that judges, after they've heard the arguments, should go back and create new arguments to arrive at a decision. In your dissents and in your opinions, you basically say they never, and I think that was in Trans Am, that they made a reference. You said you had a thought, you thought about that. Trans Am brought forth Chevron briefly. Nobody else did. And you were making a comment, y'all should have done that. Not a bunch of judges in a room when they're deliberating, but when they're making the argument. So I think you were giving them food for thought. That is extraordinary that you would do that kind of work. That's why you're going to make a great judge on the Supreme Court. And that's why I fully support it. And I will call out absurdity every time I hear it this week and next week. I will ask my colleagues to do what Republicans did before I got here. Respect the president's right to seat somebody to the Supreme Court. They don't have to vote. I've voted for cloture on nominee, attorney general that I didn't vote for. But I respect this institution and this process enough to let it go forward. So I'm going to work very hard to support you. I could, you know, I'm not an attorney, so if I said anything illegally wrong, I did stay at a Holiday Inn Express a few weeks ago, but outside of watching Law and Order every once in a while when I get home late and unwind, I don't really follow the law, but I can tell based on what I've heard today, you're a man of extraordinary patience. Yesterday I mentioned that I thought your at-rest heart rate was about 4. I saw it spike up 50%, maybe to 5 or 6 today. But I'll leave you with this. Peyton Manning, who I love, he went to the University of Tennessee, and then he tarnished career by going on to the Broncos and beating the Panthers in the Super Bowl. Oh. But let me tell you something that Peyton, I love Peyton Manning. In fact, I've got a quote on his wall that I make my staff look at every day. And it says, pressure is something you feel when you're not prepared, when you don't know what you're doing. You clearly know what you're doing. You haven't exhibited one iota of pressure. That's what's going to make you a great judge. The respect that you've shown when disrespectful questions were lobbed your way was remarkable. And I appreciate you being here. I appreciate your patience. And I'm going to yield back the rest of my time, but I will say that the break after 7 o'clock tonight also doesn't replace date night. So you owe your patient wife a good dinner after all this is done. But thank you, and I yield back the rest of my time. The senator from Louisiana.
Senator, thank you.
Yeah, and by the way, you didn't get to talk much, but I promise tomorrow you get to talk a lot.
I've heard myself speak more today than I'm accustomed to.